because we can't get to that stuff if we don't get democracy working first. If the organizations in our country who are offering better research and analysis, or offering research analysis, it is hard to find anybody better, any organization better than the Brennan Center. We hugely appreciate their work. Thomas Wolfe is with us now. Thomas Wolfe, you there?
Yeah, I'm here. I'm sorry about the difficulties. I've been out on the road, so my normal setup hasn't been geared up. Sorry for your listeners if they had to deal with some kind of gnarly feedback there.
Well, it's nice to have you. What are the key things you're working on right now?
So I've got two things in the hopper. I mean, I think the main thing that folks might be really interested in right now is trying to convince the Supreme Court to finally do something about extreme partisan gerrymandering. We had oral arguments here in D.C. yesterday. I was in the House for that. And I'm happy to talk a little bit more about what I saw and what I heard.
Well, I'd ask this, I guess. One of my concerns is that if the only people who care about addressing gerrymandering or gerrymandering, it was Elbridge Gerry, as I understand. I never met the man, rather than Elbridge Gerry. But the of extreme warped redistricting. If the primary concerns happens from a bunch of libs and a bunch of blue states, and blue states do something about it, red states don't, then that could actually be a disadvantage to blue state voters. How is the message of trying to address the redistricting in a sensible way, how is that playing out in different kinds of states, and what do you think might happen next?
Well, the interesting thing, particularly right now for the court, is that there are two maps that are in front of the justices, one from North Carolina, one from Maryland. The North Carolina map was a gerrymander created by Republicans to disadvantage Democrats, but the Maryland map was a map that was created by Democrats to disadvantage Republicans. So the court now has an opportunity to rule in a way that's going to deal setbacks to both parties and make it clear that, you know, if you care about having a representative, accountable democracy like our Constitution requires, you should get behind this particular ruling and listen to what the court has to say.
And where do you think, and so what have been the most recent judicial pronouncements? I knew that a couple years ago, folks were hoping that Justice Kennedy would say that extreme partisan gerrymandering itself was a violation of the Voting Rights Act. I think I have that right, but then he stopped short of that. What's the current state of play?
Yeah, you're exactly right. For 30 years, we've been looking for the court to finally say not just that extreme partisan gerrymandering is unconstitutional, which kind of an interesting factoid is that justices from Republican administrations and Democratic administrations in terms of their appointments all agree that extreme partisan gerrymandering is unconstitutional. What they haven't been able to figure out yet is what the legal rule should be for figuring out when a map's extreme and when it's not. We thought Justice Kennedy might be a swing vote to finally form a majority for a rule. He stepped down. He was replaced by Justice Kavanaugh, but it seemed like on the basis of last year's oral arguments that even Chief Justice Roberts and Justice Alito could be in play because they were troubled by this. And this is important for what's happening now. Justice Kennedy last year said, well, what if you had a law that was passed by a state legislature that said when we draw the maps, we have to disadvantage one party entirely and advantage another. And Justice Alito, the chief, they also thought that there was something constitutionally wrong there. That's exactly what's happened in North Carolina. That's exactly what's happened in Maryland. You've got the Democratic governor, former governor in Maryland, and Republican legislators in North Carolina both saying on the record, the reason why we drew the maps the way we did was to max out the seats for our party and lock out the other party. And in that kind of universe, it might be that there's more than just 4 or 5 votes in play. There could be up to 6.
So as I recall, part of the challenge, you'll need to remind me here because my memory is hazy here, that was it problems of proof, which is how do you know when something is extreme partisanship, or maybe even more so, what's the remedy? How do you make sure that the next map is in fact okay? What would you say is the trickiest legal conundrum that not just partisans would be concerned about?
Yeah, the interesting thing is that I think if your main contact with partisan gerrymandering legal talk is through like magazines, you may get the sense that we're almost like Nick Cage, like in the National Treasure movies. We're trying to find some deep constitutional secret that no one's been able to figure out for hundreds of years. The court actually knows, and I think this term, it's seen that these extreme maps violate like really basic constitutional rules in a lot of different ways. So the question for the justices is not really how does it violate the Constitution? The question for them is a much narrower one, although I'm not going to say it's a simpler one, which is, how can we do something here, really, curb the worst abuses without producing hundreds or thousands of new cases, because we can't handle all of those. So what's the limited way to get in? And that's what plaintiffs need to give them, is not, here's why it's unconstitutional. It's, here's why it's unconstitutional, and here's how you can get in to make some changes without getting into too much. Yeah, so what's the standard, or what's the answer to that? Try to navigate between that rock and that hard place, that Scylla and Charybdis of, on one hand, doing nothing, and on the other hand, having hundreds or thousands of cases. Yeah, I think there's a legal answer here, and then there's a practical answer, and the two of them go together. So the legal answer is to focus on extreme partisan gerrymanders, and this is something that we outlined in our friend of the court brief to the court, where you want to focus on situations where the people drawing the maps had the intent to max out their seats and lock them in for a whole decade. You want to look for cases where that's actually happened. And there are a couple things you can look at to try to suss that out. So, like, normally these kinds of extreme maps don't pop up except when one party controls the whole redistricting process. So if there was compromise or bipartisan compromise in the map, maybe that doesn't get knocked out. And you can also look at things like, how was the map put together? Was one party completely excluded? Was it run entirely by party leadership? If you focus on those things from the area of law, it only puts a few cases or a few maps into play, because that stuff has only happened maybe 6 times with congressional maps this decade, and about a dozen times at state legislative levels this decade. The practical argument is, if the court doesn't set a line now to take out these worst abuses, the worst abuses are going to become the norm next decade, because the facts in North Carolina and Maryland are as terrible as they're ever going to get. And if the court doesn't say this is unconstitutional, then map makers are going to view that as a green light to completely take advantage of the process. So there's a legal answer, and there's a practical need to do something now. And the legal answer is that, and if we can, and thank you to all of our Free Speech TV viewers who are with us on this. What do you think that is? What do you think that standard is? I back in the day was a law clerk for an Article III judge on the Ninth Circuit, and so there'd be debate. The funny thing to me was that most of the debates, when you'd get somebody else's bench memo, were nits, where you'd respond with well, you put a semicolon in the wrong place. But instead of actually arguing over the key principle, where I wish there would have been much more argument. But what do you think is that key principle? What do you think is a standard that you could imagine? Because it's not going to be, we know it when we see it, and it's not just going to be the words, well, you can't do it real bad. You can do a little bit, but don't do it real bad. What's the way to say don't do it real bad that you think Alito and or Roberts could get behind, that you might predict or advocate for? Yeah, and maybe Justice Kavanaugh as well. I think that the message that the court should be sending is relatively simple. What they should say is, when one party controls the process and it uses the process to max out its seats and lock them in for a full decade intentionally, that's an unconstitutional extreme partisan gerrymander, and the map should be struck down and redrawn.